Seriously, John? Ready to roll?
Ready to roll?
Okay. Good morning, everybody. Thank you for being here in this ridiculously cold polar vortex that we live in. My name is Ben Johnson. I'm the president of Johnson Law PLC. We have offices in downtown Detroit and downtown Flint. This case, that we're calling our Oxford shooting case, sadly, is a case that's going to be something that we're going to talk about today, and that is the protection and the welfare of our children. And that includes all children that go to school, like each and every one of these members of these families did, and so happened to be in Oxford. I want to introduce everybody so you know who's involved currently, and I'm going to start on the right. This is Jeffrey Stewart. He's an associate attorney with my office. Jeff Stewart is one of the foremost school law experts in Michigan and in the United States. Jeff had his own firm along with Bill Cycle, another great lawyer, school law specialty lawyer. And they've done cases all across the country, but especially here in Michigan, in situations involving the rights and welfare of children, which is the central issue of this case. Next to Jeff, we have Chad and Megan Gregory. They are the parents of Keegan Gregory. Keegan was a 15-year-old freshman at Oxford High, and Keegan, unfortunately, was with his best friend Justin Schilling in the bathroom trying to get protection when unfortunately a crummy shot Justin right in front of him. And then what you'll hear from the parents today is how obviously Keegan can't get over it, will never get over it, and will live with that like we would all imagine, but we can only not imagine the suffering that he and the family have gone through. So you'll be hearing from them this morning. To my left, we have William Buck Muir and his wife Sherry Muir. They're the parents, of course, Tate Muir, and he was a 16-year-old junior. And we have in the front row Tate's brothers, both Todd and Tyler, I should say. Sorry. I'm joking under pressure. Sorry. So we have Tate, Ty, and Trent. Sorry, Trent and Ty, I butchered it. And our good friend of the family, Frank Kerr, and a good friend and counselor to the family. So thank you all for being here. All of these folks are our clients. We also have Ms. Lauren Aliano on behalf of her two daughters, Sophia Kempen and Grace Kempen. Sophia is a senior at Oxford, age 17. Sophia is age 15. And they're not going to be joining us today. And you're not going to see pictures of Keegan today because the clients have asked us not to. So you are going to be given access to some photographs and so forth of Tate. And that obviously is with the family's permission. All right. Next, I want to introduce, you met Jeff Stewart of our office, but I want to introduce the entire team because these folks, since literally the first day of December of 2021, have been working night and day to put this case together. I'm really proud of them, and I appreciate them, and I want to publicly thank them. And the clients, of course, met everybody who know that they're going to be working on the case forever. So on the far right, so on my right at least, Chris Desmond is our chief appellate attorney. Chris handles all major appeals, and you'll find out later today as part of this case because of some of the current, what I believe to be atrocities of Michigan law called governmental immunity. This case will go up on appeal, and it will take literally years and years because of the extra steps that we have to go through here in Michigan when you sue somebody who is an employee of a municipality or a state. Called governmental immunity. You can't sue unless they say you can, and then when they say you can, they really don't mean it. Next to Chris is Ken Carr. He is a lawyer and associate of our firm. We're going to be working with Jeff Stewart and me. We have our paralegal, Danielle Aspen, my executive assistant paralegal, Hassan Gammons, and Tiffany Gagne, also paralegal working with Ken Carr and Jeff Stewart. That's our team. I'd like to thank you guys for everything. And I just want to say, while you're standing here, you folks will be given access today to a 35-page complaint. We call it a complaint. It's a lawsuit. It was filed at 8:32 this morning in Oakland County Circuit Court. It's one of the most detailed and lengthy complaints that I've ever utilized in 36 years of practice, and that was from all the hard work, Jeff Stewart and the entire team. So thank you, everybody. Thanks, folks. Appreciate your time. All right. What we're going to be talking about a lot today is obviously going to be about Tate, what his death has caused him and his family, which is so difficult for anyone to talk about. We're going to talk about with Keegan, parents, Megan and Chad, what he's going through and how difficult this process is. Lauren, on behalf of her two daughters, they were in the classrooms. And literally what happened here on November 30th, 2021 is something that we've seen all across the country, but apparently we thought here in Michigan and Detroit metropolitan area were immune from it. And the sad reality is folks who have school-age kids, and I'm blessed to have two little kids, and I'm glad that my two older kids no longer are this age, to tell you the truth. Because we've had to have conversations with 11, 10-year-olds about going to a school that nothing bad happened in. I can't imagine. Can't imagine what these folks have done. The Mears having to bury their son. The Gregories having to beg their son to come out of his room and hiding. It's unimaginable. No child should ever have to go through this. And what's perhaps the saddest of all is under Michigan law, no child should ever go through this, because we have so many things in the law already in place that unfortunately is not being very well enforced. And because of what I believe to be some entirely wrong and very what I believe to be butchered logic, appellate court decisions, what we're doing is we're protecting the people who had notice that could have prevented this, instead of coming forward like the law requires. Here's the non-sexy part. You guys can tune out. Sorry, the law. It's called Child Protection Law. Michigan Compiled Law 722.621. Child Protection Law. None of us know, probably. It went into effect on October 1, 1975. Did you all know that we have mandatory reporters under Michigan law? Did you know that if they don't report like they're required to, if they have a reasonable cause to suspect child abuse or child neglect, which involves not getting a child the type of medical or psychiatric help that clearly even crumbly needed for months and months, that there's civil penalties and there's criminal penalties. I don't do criminal law. Prosecutor McDonald, Sheriff Bouchard stood before all of you. I watched much of this stuff, like so many other members of our community probably did, on that horrible day, November 30 and December 1, 2021. And I heard something from a prosecutor, and I heard something from a sheriff in a large metropolitan community do something that has never been done before in my recollection, and that is they called out mistakes were made by the school. We're not going to be talking a lot about that today. Mistakes were made by the school, and no one told us being the authorities. Ladies and gentlemen, this is a violation of the Michigan Child Protection Law, the law I just told you about. Child abuse. A lot of people think they know what it means, and they think it means when someone is physical and hurting a child. That's certainly part of it. But under the law, child abuse means harm, threatened harm to a child's health or welfare that occurs through non-accidental physical or mental injury. Mental injury. So back in 1975, they were already thinking about kids suffering from mental illness and how they need to be protected, or maltreatment by a parent or someone responsible for that child. Child neglect means harm or threatened harm to a child's health or welfare by a person responsible for their health or welfare, which includes failure to get appropriate medical care. Like a kid who's clearly either homicidal, suicidal, and he's calling out for help so loudly that he actually was dumb enough, which I don't think he's dumb at all, to write pictures in school. And they saw them with people bleeding. I'll show you. You've seen them before, but I'm going to show you again. This kid, Ethan Crumley, do not misunderstand my words. He is a part of our lawsuit. So are Mr. and Mrs. Crumley. They deserve to be held accountable criminally and civilly. They're in this lawsuit. But what cannot be ignored by these parents, by our community, and the law, is when you violate the law and it leads to something horrible, you have to be held accountable as well. And these brave people are here before you folks to talk about that and to seek justice against the school personnel who were responsible. For the first time today, we're going to share the names of some of the folks. We don't have all the names, but we have some, and I'm going to share that in a minute. I told you that Michigan Law 722.623, individuals required to report child abuse or neglect. An individual is required to report under this act as follows, and they have a whole list of the types of people that must do it. Licensed professional counselor, social worker, licensed master social worker, licensed bachelor social worker, and it goes into school administrator, school counselor, or teacher. Sound familiar? School administrator, school counselor, or teacher. And here's what the law says, folks. Those people who have reasonable cause to suspect, that doesn't mean you have to have definitive proof. When you see something that looks really bad, then we want these folks to err on the side of caution and report so that the authorities, police, Child Protective Services, CPS, can do their jobs and figure out, is there something going on here or not? That's their job. But a teacher, school counselor, administrator shall make an immediate report, not when you get around to it, not in 48 hours. An immediate report is what the law requires to the centralized intake by telephone or, if available, through online reporting services. And it goes on and describes the type of documents that need to be done. In this case, we had the Oakland County Sheriff Department liaison officer have an office, apparently, and apparently he wasn't there on the 30th, the day of the shooting. Tell you when I get the depositions of these folks, whether he was there or not on the 29th, okay? But what we got to realize in Oakland County, and what you've not heard from the school district yet, sadly, it's a task force that Sheriff Bouchard has put together on this, ladies and gentlemen, to look into these things ahead of time, obviously, hopefully, to try to prevent this very thing. All they had to do was call 911, and they never did. Under the same law, that if a notification to a person, because here's where the school district's going. How do I know this? Because I'm sure you folks have read the letter that was done by Mr. Thorne on behalf of the school district, that I promise you when I take his deposition, he'll tell me it was drafted that with his lawyer, probably Tim Mullins, in the school district insurance company. Under the Michigan law, the reporting statute says, a notification to the person in charge of a school does not relieve the member or staff of the school if they, in other words, notify somebody else. And what Oxford has told these parents, sadly, instead of, where have we seen from Oxford, we understand we have obligations under the Michigan Child Protection Act and we blew it. You'll never hear that. Because the sad reality is they did, and it's gotta hurt. But that's their job to step forward as an adult, as an administrator, say, mistakes were made here by us and we're sorry. Instead, we get the lawyer letter, we get the internal investigation that should have been done by Dana Nessel. They turned that down. Why did they do that? So they could hide this report from us and claim a thing called work product so that we can never find, which I think the judge will let us find, but they're hoping to keep it private. So once the report says, here are the things that you guys missed, that no one gets to hear about it. So the very thing that the excuse that the school used is the teachers didn't report, and I'm going to go over the facts in a minute, but the counselor took over, and then ultimately the dean of students took over. This law specifically says this does not absolve you. This does not prevent you from being held responsible simply because internally you turn it over to somebody. Under the Michigan Child Protective Law, not only do we have mandatory reporters, but under 722.624, it says, in addition to all the people who have to report, any person, including a child who has reasonable cause to suspect child abuse or neglect, may report the matter to the department or law enforcement. Translation, hey, if you think that you're not a mandatory reporter, you still can do this. And we want you to err on the side of doing this because it protects a kid. One of the things that I hear, because I've been doing this work for 36 years in these instances, well, we didn't want to report because Johnson would sue me if in fact I reported and it turns out the kid wasn't abused or neglected. The next law, 722.625, completely says that if you, in good faith, in other words, if you were trying to do the right thing and you report, you are immune from lawsuit. Translation, Johnson can't sue you under the law. Oxford, don't even think of using this as an excuse. The last part of the law I'll bore you with. And I really hope some of you out there, especially in the print media, but I hope all of you really think about doing an extended show, if you will, or whatever you want to call it, in-depth analysis of this law, and check me out because I'm reading it to you. This is what the law is and what it should be, but it's not in reality. We'll talk about that too. 722.633, failure to report suspected child abuse or neglect. A person who is required, mandatory reporters, to report an instance of suspected child abuse or neglect who fails to do so is civilly liable. Hence, ladies and gentlemen, why we're here, because they didn't. For the damages proximately caused by the failure, that's related to the failure. Here we know what was proximately caused. They not only didn't stop Ethan, who was apparently psychologically trying to be stopped, but they actually ended up giving him the very backpack that contained the gun without ever searching it. I will share that with you in a few moments. A person who is required by this act to report an instance of child abuse or neglect, who knowingly fails, is also guilty of a misdemeanor, criminal. That's the Child Protection Act. So, Johnson, why are you harping on this? Why is that so important? It seems pretty easy, close and shut. I wish that were the case. In Michigan, we do this thing thanks to governmental immunity where we elevate the rights of people who we're trying to seek redress from, who did us wrong. If, God forbid, this very same instance happened in a private school, and I won't mention any by name because no one wants to even imagine it, just like Oxford doesn't. If this all happened at a private school, there would be no governmental immunity because it's private. And I would be able to sue these people under the Michigan Child Protection Act and prove negligence, which is just the failure to do something that a reasonably prudent person would do. We talk about negligence every day, all day. We all know what it is. It's a mistake. They made a really bad mistake and it hurt somebody. That's the proof I'd have to prove. But because these folks are employed by a municipality or the state, governmental immunity applies. Ladies and gentlemen, under Michigan law, I can't even sue Oxford as an entity. I want to. They deserve it, but I can't. Under Michigan law, I can only sue the king when the king lets me. And then, like I told you before, when he lets you or she lets you, they don't let you very much. And it's really somewhat of a kind of a hollow promise that you can. Under Michigan law, since these are public employees, I have to prove what's called gross negligence. It's a higher standard. It protects the guilty. Gross negligence is negligence that's so beyond the pale that, in essence, it assumes that somebody either willfully on purpose or intentionally, recklessly, dangerously blew their job. Now, I think we're going to be able to prove that here. But the way that Michigan law has interpreted this law for the last, well, 30 some years, but especially the last 20, is they throw these cases out of court all the time and never get to a jury because they say, oh, this doesn't rise to that level. Well, how do you know that's a jury's job? No, under the law, it can't. So they throw these cases out. They also have to prove, we have to prove when it's a governmental agent that it's the, T-H-E, the proximate cause. Oh, here comes the lawyer giving definition. Sorry, this is crazy reality of Michigan law. In a normal case, I just have to prove a proximate cause. A relationship, one of many, between the negligent conduct of somebody, ran a red light texting, and them breaking my leg and me needing surgery. That's pretty easy to do. When you sue a governmental person and governmental immunity applies, and we've heard this debate about sovereign immunity, governmental immunity, it's pretty much the same type of thing. I now have to prove the proximate cause, and I promise you the school district is going to come in here and argue the proximate cause, Johnson, Mears, Gregory's, and Aliano, the proximate cause was Ethan Crumley. We're not responsible, even if we screwed up. So, welcome to Michigan law. And what we're going to talk about here today, and the folks, I don't normally do this. Many of you in the room know me. I don't normally give you 100% access to my folks, but in this case, I think you need to hear it because I think the public needs to hear that currently under Michigan law, suing a public employee, you have less legal rights than those public state employees. And to me, that's unconstitutional and wrong. All right, I do want to spend a couple of minutes, and forgive me, because we're going to talk about what the lawsuit says. And where's my, what our lawsuit lays out, you folks will be given access to, is the overwhelmingly substantial evidence that clearly Ethan Crumley was a mentally ill child that needed significant intervention. And we've heard the term therapy in this case. And he didn't need therapy on November 30. What he needed was immediately psychiatric, to be hospitalized and evaluated as cause. Therapy suggests that he's not going to harm himself and someone's just talking through his problems. That day, he needed to be taken to an emergency room and seen. Same thing the day before November 29. Actually, probably long before that, when we hear, as you know, in the lawsuit, about somebody for the entire year of 2021 was on his own computer, on his cell phone that his parents gave him, shooting videos of himself hurting animals, killing animals, and obviously laughing about it and posting it. And we've all seen these stories. We've all read the same stuff. When you have a child that is hurting an animal, that is a precursor to someone with high violent propensities. It was a telltale sign. You could check the box of what I'm about to read to you. Any psychiatrist, any school psychologist would tell you this is a troubled child who needs to be evaluated. Yet they sat idly by. And when they had the chance to stop it, they did. Ethan, as you folks know, was clearly absolutely in love with guns. On computers, looking up Nazi propaganda, making Molotov cocktails at home. He's looked on his computer, on his home computer, so many times about school shootings and firearms that they're sending him ads, okay, which I didn't even know existed until this case. Send him an ad like, hey, dude, like, you know, we see that you're checking out school shootings so much, and they give him a reference to a mental health facility. We see that he was allowed to shoot, and hear me out. We're not here to talk about the right to have firearms and so forth in this case. Clearly, his parents had the right to have them. But when you have them, you got to be responsible, and you got to make sure that they're absolutely locked away, and they're not ever going to be available for someone to use without your express permission. Like anything else, a car or any other major thing that we allow our adult or adolescent kids to have. We know that Ethan, even in August of 2021, shooting guns and posting things. And we know again that he sent a message to his friend it's time to shoot up the school. Just kidding, just kidding, just kidding. That August of 2021. And no one did anything. But at that point, right, that's the Crumleys. No question about it. And then you look at all the way in November, you have this kid who is going through clearly something. One of the things that really kind of saddens me, where the investigation revealed, you've all, I hope, seen it, where they found that Ethan was calling his mom or texting his mom while he was home alone and saying that he thought there were demons and bad spirits or someone in the house. And she would absolutely just leave him there and really do nothing about it. And any good psychologist or psychiatrist would tell you, if you have that ongoing, you need to look into that and make sure your kid's not having hallucinations. These are strong indicators of mental illness. We get to now November, and they know that Ethan has been wanting a gun for Christmas. It's not just a gun, folks, a 9mm Sig Sauer semi-automatic handgun. That's not just a normal Christmas present, at least in our house. They're entitled to have it, but they're required to make it safe. And they didn't, the Crumleys. And you now know that Ethan posted less than 2 weeks before the shooting, him shooting. And we know that this is the gun I'm going to use. This is 2 weeks before the shooting. Now, I don't know about you folks, but at our house, we have parental monitors on cell phones and computers. Dad bought the gun with Ethan on the 26th at Acme, openly refers to the gun as Ethan's Christmas present in front of the gentleman that he's purchasing it from. The next day, November 27th, 3 days before the shooting, Mom takes Ethan to the gun range, and then she posts, this is Mom, Miss Crumbly, Mom and Sunday testing out his new Xmas present. My first time shooting a 9mm, I hit the bullseye. With all these indicators, this child is now being given the gun. And we know that he was journaling. We know that he was videoing. The investigation has revealed this. If you guys, I hope see it, it's all in our complaint. That he was videoing and journaling that he was going to shoot up the school. No question that the Crumleys had access to all of this and should have known if they didn't already know, and I think they did, that Ethan was thinking about this and was stuck on that idea and couldn't get it out of his brain. Talk about the day of before the shooting. And the day before the shooting, you've already heard, I'm sure, about that he was in class and that he was searching for ammunition. And the teacher was so concerned, we call it in our lawsuit Teacher One because I don't have that teacher's name, but the teachers, folks, are mandatory reporters. And like any school, we've already gone through the policy and procedures of Oxford. You can't be on your cell phone at school. And you certainly can't be searching for ammunition. And if you do, red flag, and there should be and is in any other school that I know, maybe Oxford's going to tell me different here. Zero tolerance for violence, zero tolerance for ammunition, zero tolerance for guns and weapons. Zero. So the teacher saw that, took a picture of it, of the ammunition, which we don't have yet, or I'd show it to you, and then send it to the counselor, Ms. Pam Parker Fine, F-I-N-E. I told you and read you the law simply because you have an internal procedure that says that you don't, that you're passing this person on, and it's now going to be their job to figure out whether there's suspected child neglect or child abuse. You can't get out of that by not reporting. And it's our position, and we think we're going to prove overwhelmingly that that teacher, knowing this student, and folks, we don't even have this kid's school files yet. So I promise you, as I sit here before you, after 36 years of doing this stuff every single day, there's going to be a lot more to talk about his background and what these teachers and administrators knew about this kid and what he was going through. So what happened that particular day is she then, the teacher sent her down to the counselor, Ms. Fine.
What you may not have known is on that very day, investigation has now revealed that other kids in his classroom, this is Monday the 29th, folks, the day before the shooting, saw him with casings and live ammunition. Now, why did the investigators know that? Why haven't we heard that from the school? Did they know? And if they didn't know, why didn't they know? If I got a kid in class, if I have this kid in my house and he's on his cell phone looking up ammunition, it's like, whoa, dude, what are you doing? Okay, go to my kid. Did you see what he was doing? What were you guys talking about? Let's get some information about what's going on here. We've heard none of that until the prosecutor in this case revealed that fact recently in a court proceeding. So other kids saw gun case, right, shells, ammunition, live, and casings spent. Okay, did he have the gun that day? He gets down to Fine's office, and this is again a school counselor, mandatory reporter. I just read it to you. He gets down to her office, and she begins to interview the kid and calls mom, Mrs. Crumley. Mrs. Crumley never calls her back. So what does she do? Sends him back to class. Wait a minute, what were you investigating? What did you think was going on? Why would a kid in the middle of the school day look at ammunition on his phone? What does it tell you about what's going on in the home? And if you don't know the answers because mom's not calling you back, who doesn't call back, guys? Who doesn't call back? The level of suspicion went from highly suspicious to off the charts, knowing something's wrong here. So she had reasonable cause to suspect child abuse or neglect, or something in this home is going on here that's leading this kid to do something that's so dumb. He's doing it in public and people can see what he's doing to the point his teachers saw him. In fact, the prosecutor has talked about that he got caught. Caught means you're doing something wrong. He knew what he was doing. It's almost like he wanted to be caught. So what did she do when mom didn't call? Send him back to class. That is a violation of the Child Protective Act. What follow-through was there? Where was the second phone call? Where was the email? Where was the principal? Where was anybody? And we don't have that yet, but we'll tell you when we get there, because we're going to take the depositions of all these people. Now we got the next day, the 30th, the day of the shooting. And you all have seen and heard a little bit about what's going on that day, but there's actually two teachers involved in that day, and we describe them as teacher 2 and teacher 3 in our lawsuit. We've heard about the teacher and the drawings, which I'll show you again. But what we didn't hear, I didn't hear, until just recently, the investigation revealed, is it the same teacher or different teacher? Can't tell you yet, because they haven't turned that stuff over yet since the prosecution is still just getting up and running. But another teacher saw Ethan on his phone watching a violent video of a shooting. Again, in class, folks, at school. Who would do that? Think about that. He knows he's going to get caught. And in a weird psychological twisted way, he apparently wanted to be. And they just ignored it. The other teacher saw what you've all seen is his test review paper. These are the drawings at 8:59 on November 30, just a few hours before killing Tate, before killing Justin and the other children, and right in front of Keegan and threatening him right to his face. This gun looks a lot like the gun I just showed you about that was posted, because that is his gun. That's his Sig Sauer. Underneath it, the thoughts won't stop. Help me. A person with 2 bullet holes, apparently waving because it's a kid, with blood all around. A bullet, blood everywhere is written. Smiley face, actually someone laughing, smiley face, so crying that they're laughing so hard. My life is useless and the world is dead. You don't have to be a psychologist or psychiatrist to see this and feel the sadness and desperation of the person writing this on his chapter 5 test review of using congruent triangles. Not anything to do with the schoolwork at all. And the teacher saw this and obviously took a picture of this. We've all read that. But now we have the teacher seeing the violent video of the shooting. We have a drawing of a violent shooting. We have a person bleeding out. We have a gun. We have a bullet. Other than simply saying, by the way, I got my gun in the backpack that's in the room with me here, because it was. I'm going to shoot up at the school today. What else could be possibly would somebody want to know in terms of warning? So what we know is the teachers, of course, sent this down to the administration again. And again, what they're going to do is they're going to tell you, oh, wait a minute, that's how we do it at Oxford. Well, not according to the Michigan Child Protection Act, you don't. You won't get out of it because you have some internal policy that says you don't have to report when under the law you do. So he gets sent down to the counseling office, is my understanding. They say office, and they're not very specific, but we'll get there. And that's when he gets to see counselor number 2, who is Mr. Sean Hopkins. And Mr. Hopkins, to his credit, gets Nicholas Ejak, E-J-A-K, involved because he's the dean of students. The way apparently Oxford works is that the counselors are supposed to be involved if they have concerns about somebody that might need some psychiatric or medical care. They might be concerned about suicide. Apparently they weren't worried about homicide, but we'll get to that. And then the discipline end goes to the Mr. Ejak, the dean of students. So what happened was they went and they interviewed Ethan, and Ethan knew he was now in trouble. So Ethan thought he would obscure the evidence. Ethan crossed off the handgun. Ethan crossed off the words blood everywhere, but he left the bullet, interestingly enough. The thoughts won't stop. He didn't cross off, interestingly, but the line, help me, he crossed off. He crossed off the blood everywhere. Video game this is, he wrote. And then he crossed off, my life is useless. He wrote in harmless act. He added, I love my life so much, with 4 exclamation points, and OHS rocks. We're all, well, he spelled we're wrong, but we are all friends here, he wrote, and crossed off the my life is useless and my world is dead. Any psychologist, any social worker, any person with half a brain, would know he got caught and he's covering up what he did wrong. So the fact that he actually did this is even more evidence, in essence, that he was trying to make it so obvious, I'm in trouble here. So what did they do? Mr. Ejak, Mr. Hopkins, they called mom and dad. And what their what their statements have been to the investigators is that we called dad, and when he answered, there was just dead space air. We then called mom. Remember, mom was called the day before and never responded. This time she apparently picked up, and they asked her to come in and say, we got issues with Ethan, we need to talk to you right now. And she said, I can't because of work. Now, what we don't know yet is the interplay between Ms. Fine from the day before and these gentlemen, but I don't know about where you all work, but I know this, if something's going on in Jeff Stewart's office, and he's not right next door, these folks, I'm sure they are because they're both counselors, but Jeff Stewart's going to tell Ben Johnson, man, something really weird happened here. I called the mom and she never even got back to me when her kid's looking up ammunition at school. So I believe the evidence is going to prove these two spoke and they knew what was going on. And what happened was these folks finally came to school, and they have Ethan now apparently in a separate room. He's explaining all this nonsense away through lies and deceit, covering it up. And the parents, the investigation has revealed, were not impressed with anything, didn't think there was a problem, nothing bad's going wrong. And oh, by the way, is the meeting over? So I say to you, your level of suspicion was high before. But when you have parents that look you in the face and either don't give a flying hoot or are just so oblivious that it doesn't register, all you have to do is make one call. It's called 911. There's a liaison officer from Oakland County Sheriff Department that works at Oxford School. Apparently wasn't there that day, but that's why we have these things called phones. I don't know about you all, but I carry mine right there. Call 911. We have a kid drawing 2 days in a row about guns, so forth, hurting people. We need your help. Come figure this out. And if they had done that, what would have happened is they have a task force in the Oakland County Sheriff Department, ladies and gentlemen, for this very thing. Some of you may know, some of you may not know. Part of the task force is the FBI. They get involved in these things to investigate, to see what's going on, and if there's other people involved, and if there's going to be a shooting. They never made the call. When the meeting was occurring with the parents in the room, Hopkins and EJAC told the parents that they suspected that Ethan had suicidal ideations, fancy terms for, we think the kid's going to hurt himself. There is, I believe, once we get into this, there's going to be evidence that there have been previous suicides at Oxford High School. My understanding is that there's been a couple in the recent past, so this issue was supposedly on the forefront of everybody's mind. Should have been. But apparently it wasn't. And what they ended up doing is they said to the parents, you need to get Ethan, they call it therapy. It's not therapy, it's intervention now. I ask you, think of what happened if this was at your house. What would you do with this kid? Now he's on his cell phone. He's writing pictures of this stuff. Would you let him near your kid without seeing what he's got in his hands or in his backpack that's, by the way, no longer with him? They left the backpack in the classroom that he was in. So now he's in the office without the backpack. Wouldn't you want to ask him, do you have a plan? There's protocols. And then ultimately what I'm going to do is say, hey, mom, hey, dad, our kids were playing at our house, but this is no longer fun, okay? You come get this kid and take him for help right now, or I'm calling the cops. 911, and let them figure it out. Child Protection Act. I'm permitted to report reasonable cause to suspect something is very wrong with this kid's health, welfare, and medical condition. They never did. So they wanted him to get immediate help that day, and the Crumleys refused. Level of suspicion goes from high to guaranteed something's up with this kid. Apparently, Mrs. Crumley told them, we can't take him home. We don't have time from work. So no, I'm not taking him home. Well, last time I knew, if your kid gets suspended or they tell you to send him home, you have to. What did they do? The Crumleys left and they told him when they were going out the door, you've got 48 hours to get your kid help or call Child Protective Services. Sound familiar? CPS. Nice try, but you needed to do it that day. Immediate is what the law says. Immediate. So what did they do? Crumley's left. Ethan stayed at school. Time had passed, so it was a different hour of classroom. And based on our understanding of the facts, Mr. Hopkins, being the counselor, went down to the classroom, got the backpack, brought it to Ethan, and gave it to Ethan without searching it. Let me say it again. He gave him the backpack without searching it. And I go back to my analogy. If this is at your home, what would you do? I wouldn't even ask. And you can tell me, then there's a law. Good luck with that. Absolutely had an obligation to. This is beyond gross negligence. Ethan then goes back to class. His parents leave the building somewhere around 11 o'clock, and we know before 1 o'clock, less than 2 hours later, his rampage and what it did. So my clients are very sensitive to the fact that this is their community. My clients, our clients, are very sensitive to the fact that this was their high school and that these were the people that they entrusted with their children. They lived there for a reason. They wanted to be there. They're a close-knit community and they liked the school. But these errors are so far beyond negligent. They are grossly negligent, even though we shouldn't have to prove that. We will. And they are absolutely the best opportunity that anyone had to stop Ethan from what Ethan was clearly there to do that day. Because according to the investigation, the gun and the ammunition was in his backpack. So, when people ask, and you're going to want to know, why are you doing this? You're going to hear it from these folks. But everyone responsible should be held accountable. Everyone responsible should step up and have to face the ramifications. I'm not the Oakland County prosecutor, so the Crumleys are all charged criminally like they should be, and they are guilty, all of them. Hence, we sued them in this case because they are partly responsible too. So are these folks from Oxford. And as evidence comes forward in the case, if it leads us to more people that violated the Child Protection Act, then we will be bringing them to justice as well. The last thing I'm going to mention about lawsuits and civil, I'm not the prosecutor. I can't put them in jail. All I get to do is ask for money. You folks love that question. I don't blame you. At Johnson Law, we don't put down large numbers in a lawsuit just to get your attention. You guys, we have your attention, and we knew we would in this case anyway. It's one of the most tragic, saddest things I can think of. I've lived in Michigan my entire life, my 60 years. I can't think of anything worse than this. Fact of the matter is, we use the jurisdictional amount like we always do. All we have to do in Oakland County Circuit Court is prove and request that the lawsuit we're entitled to $25,000 or more. That doesn't mean we'll only ask for $25,000 at trial. Right now, these family members all know there's no guarantee of any outcome in terms of money in this case. But until we get to the bottom of all of this and a lot more, I know this, these families can't rest knowing that there are children in jeopardy when people who have an obligation of the law to do their job don't do their job. And in my opinion, not just do their job, but do the right thing by all of us. So I'm now going to turn it over. I've asked the families if they want to make a statement. And I'm going to do this as kind of a deal. You guys know, you guys are all professionals. I respect that. We're having this press conference today really for one reason. Don't go to my clients' houses. Don't call them on the phone. Don't send them emails. Don't send them texts if you can get their number. Please don't do that. This is their public comment. Come through me. Okay. I can't promise I'm going to produce them ever again. I'm sure I will, but I'm not going to promise that either. I know you want to talk to them. This is the day, but do it with one of us present. Please respect our rules. I know you will. And leave them alone. They've had enough. So, Buck, on behalf of you and Sherry, on behalf of your sons, Trent and Ty, family friend, Frank Kerr, would you like to say a couple words?
Good morning. Today's the 58th morning we've woken up without Tater. Tomorrow will be the 59th. Following day to be the 60th. For the rest of our lives, we don't have Tate. We're sad and heartbroken. Our lives are forever changed. Our family will never be the same. All these moments, give you a few of them that we will never get to share again with Tate. Christmas, Thanksgiving, all the holidays, his birthday.
Which just passed. Right?
Which just passed. He was a January 1 baby. his senior football season, which you all know he loved football, his senior wrestling season, his graduation, going off to college, probably playing football in college, chasing his dream, graduating from college, landing his first real job, all these major milestones that we never get to have with him. Getting married, standing up in his brother's wedding, having kids, being an uncle. None of these amazing moments Tate would never have the opportunity to have. And, you know, people are texting us and calling us all the time and asking us how we're doing. We're not doing good. All we do is walk around the house and think about Tate. We think about him every day. We sit in his room. We listen to his playlist off of Spotify. We miss him, and we're not doing good. But we're going to find a way to get through it together. A couple things I want to share. You know, you guys have probably heard a lot about Tate. I'm going to tell you a little something more about Tate. He was an amazing, selfless young man who put everybody else first. He was a great buddy to his friends and his teammates. He was an unreplaceable wingman to our family dog Cash. They were buds. He was a caring boyfriend, a loyal brother, very loyal, and a very loving son. We miss him so much. Tate had a wonderful balance of being accountable, strong young man, and having empathy for others. I see there's a picture back here of the Christmas tree farm. That was Tate loved Christmas. He loved it. He was the one knocking down the doors to go cut the tree down. He was the one helping me get it set up, making sure it was square, sharing my crazy OCD thing, making sure that thing is square, right? Absorbing everything. He loved decorating the house with Mom, making Christmas cookies. Tate loved to go to Uncle Kurt and Aunt Libby's cabin up north. Love that place. Hanging outside fires, kayaking down the river, doing some float hunting. Tate loved to hunt and fish. And Tate just loved spending time at home. You know, he had a wonderful balance of hanging out with his buddies, but he also loved to be home. He'd love to hang out at home, bring his buddies over and hang out with us. And one thing that I think, you know, that really stands out in Tate is he took his role as a leader very, very serious. And his teammates know that. He was steadfast on creating a selfless, team-first environment. He understood that you couldn't win alone. What 16-year-old kid understands that? He was wise beyond his years. He was one of a kind. He was a special kid. Want to make a couple comments about the case here. I'm not going to get in any detail here, but you know, this was really a tough decision for our family. We're fully aware that people will misperceive why we're doing this. But we taught Tate and his brothers to be responsible for their actions and always be held them and always be accountable for them. And it would be a dishonor to Tate if we didn't do this. values that we stand for as a family. So the two things that we want to come out of this obviously is accountability, and from what Ven talked about, yeah, the ball was dropped. The ball was dropped, and there needs to be accountability here. The other thing that we hope comes out of this is change. A change in legislation for government immunity, right? There's legislation passed right under our nose by our government, right? Meanwhile, while they keep us deflected on wedge issues and pushing us far left and far right, they have passed legislation that takes away our rights. Tate's rights, all the kids' rights at any public school, because they go to a public school. They have lesser rights. Let that sink in. If your kid's at a public school, your child is at a public school, they have lesser rights because of government immunity. That needs to change. Another thing we hope that comes out of this is mental health awareness. This has been a long time coming, and I get it. It's a tough issue to address. It's not measurable. It's not like taking your blood pressure. You got a measurement. Taking your blood sugar, you get a measurement. It's high, right? There's no measurement here, so it's tough. It's going to take effort, right? But we feel like this is a big issue, and our family is starting a foundation to address this issue. And it was something that Tate was really passionate about. It's called 42 Strong. And Tate loved to mentor. He loved to mentor kids. It's a peer-to-peer, right? So this is a peer-to-peer foundation that we're gonna launch, and we want to reach everybody that we can.
42 is his number in football.
42 is his number in football, right? It's 42 strong.
What's the foundation? What's the primary goal?
The primary goal is to provide peer-to-peer mentoring to kids. So we believe we need this, right? And Tate was passionate about it, so we want to carry out his passion, right? And we want to let his legacy live forever. If we can somehow, unfortunately, this shooter was raising his hand. People refuse to see that, right? But if we can reach kids like this shooter and have somebody mentor him, build his self-confidence and his self-esteem, give him an opportunity to mentor. We feel good when we help people, right? If this kid is mentoring somebody, is getting mentored and mentoring somebody and has a purpose, November 30th doesn't happen. It doesn't happen because we all feel good when we help people, right? So this kid, unfortunately, had nowhere to go. And that's why November 30th happened. And we hope our foundation changes this. On behalf of myself, my wife, Sherry, my sons, Trent and Ty, and our son, Tate, thank you for continued love, support, and prayers. They have sustained us through these dark days, and we will need it even more going forward. Thank you.
You know, returning to the Gregory family, Chad.
Morning. Thanks, Buck. Listen, I don't want to be here. It's no surprise I'm not comfortable. We have 5 children. Keegan's our oldest. And our hearts are broken. But broken for everybody that experienced what they did on November 30th. For everybody who's got their own story and their own battle. We're broken for the people that were injured and the students. And recovering mentally and physically. And we're broken for Justin and Tate's family and the kids that won't come home. And they didn't come home. And we're not tone deaf. This is a terrible time to do something like this. School went back this week. And people faced walking through those doors with courage and resolve. That's an important part of their healing. And we don't want to take that away from anybody. Teachers, the administrators, the students. But we're here. And believe it or not, I never wanted to meet Ben.
Most don't.
I didn't want to meet the Tate family this way. The Myers, or Justin's family. But we're here. And our son came home. And he was ice cold. Like a rock. No emotion. Didn't hug us back. I don't know what to do for him. And he's changed. His moral compass is shattered. He's suffered an injury so severe that it's invisible, so people won't know. That he could look at all of you in this room right now and wonder when you are going to shoot him. That's not fair. He was in that bathroom for 5 minutes. There were no cops rushing the halls. There was no one calling out for people who were surviving. He was in there with a shooter who had just killed, murdered, injured, terrified. And Justin gave them a plan. If we get a chance, we will run.
Justin Schilling.
And the shooter looked at him and he called them out one by one. And Justin happened to be first. I'm so sad for his family. And I'm guilty. I feel guilty. Because I'm also so grateful that Keegan's home. But the shooter took his 4th victim in that bathroom and he called our son out and he told him to get against the wall next to the body. And Justin's caring soul who gave Keegan the confidence and a plan. He's our angel. And the minute the shooter took his gun off at Keegan and pointed at the wall where he was going to kill him, he ran down empty hallways past Tate's body. No one was running towards him. A police officer told him to go outside. They left him there. They took him in. They put him in an office. There's no contact to us. I came home and my son, who's 8 years old, is terrified, crying. And we're changed forever. And there's no way to predict what will happen and how long this will take. Or will we have the strength? Or what will we know when Keegan's in his own head, in his room at night? And I pray for him every day. But he's hardened. And there has to be accountability because this could be could have been all. It could have not happened. And I hope Keegan's a mentor in 42 Strong. And I hope he does turn this around and he shares his experience. And we're going to do everything we can to provide him the tools and the resources and the support to do that. And money's a necessary evil. If we could say we don't care about it, we don't care. We want our community. We want our 5 kids, 4 of them are younger than Keegan and still have to go through this school. It's Ben's job to do that. And everything he said, it's our job to heal and forgive. And we'll do whatever we can for the families who lost their kids. And I'll be damned if Keegan is forgotten. He was the 5th victim that managed to run. And because he's hard on the outside, doesn't mean everything's okay. So Megan and I are here knowing that, just like what Buck said about everybody will have their perspective on what they would do in our situation. And I'm thankful no one is. But we're going to fight for accountability. We believe that Ben and the team and Jeff will do their job. And we support change and awareness. And we thank everyone who continues to reach out. And Megan and I will get up and do our best we can, one day at a time. That's it.
On behalf of Lauren Aliano, I simply want to indicate that her 2 daughters, one a sophomore, one being a senior, were in the school. And what I appreciate about all that has been said today by our clients, the tremendous suffering that they've gone through, that every person in that school, not just the kids, are victims of this entire series of events that was caused by, yes, the Crumleys, absolutely, hence they're in the lawsuit, but also because of the failures of the personnel that we've outlined. So at this point, I know it's run a little long, I apologize, but I know it was important for you all to hear what they had to say. So we're going to take some questions, Alex, Sarah?
Yes, we'll open for questions.
Good morning, everyone. Thank you for being here. Thank you for sharing your stories. It's certainly difficult. Probably the questions for Ben. You're outlining 3 school officials, naming them, which is new to us.
Right.
The prosecutor said early on that she would look to charge school officials. Then she sort of walked that back and changed it to that's on hold. You said that they're guilty at least of a misdemeanor. Do you think they should be charged? And if so, does that hamper the criminal case? Because doesn't the prosecutor need their cooperation? But if she's charging them, they're going to take the fifth. They're not going to cooperate. Your thoughts?
Well, it's a great legal question, Commissioner. Boy, you should go to law school with me. That's a great question. What's great about what I do is I'm a civil lawyer, not a criminal lawyer. So I'm going to keep my criminal law thoughts to myself because I don't really consider myself to be an expert. What the Child Protection Act clearly talks about is civil liability for a knowing violation at the same time as a criminal charge of misdemeanor, if you will, if that's what the prosecutor decided to do. Personally, everyone has their own opinions on all this. I think Karen McDonald has been an absolute hero to these folks and talked the truth about the Crumley's involvement and, by the way, the school's involvement. just like Sheriff Bashard did as well. Give them both credit. In situations like this, it's rare. So, sorry, Jim, but I am gonna give you the lawyer duck, and that is that great question, but you have to ask Karen McDonald. I'm not critical of her for anything that she's done as it pertains to my class. I'm just gonna stick with my job and let her do hers.
We'd also like to invite the Zoom participants to ask via the Q&A feature for those logged in.
Appreciate you all being here, and condolences to everyone involved. A couple of questions, if I may. At the time following the news conferences, the sheriff indicated that he did not believe any individual students were targeted. You mentioned about calling out of names. I'm curious if anybody believes students were targeted in particular, or if it was just that this shooter was in the bathroom with your son at the time. I just want to make sure that's addressed, and if there was any targeting, if anyone knew.
Well, let me take, you're welcome. Go.
He didn't call their name. He
My-
just called them out.
Call them out of the bathroom.
I see.
My
I
understanding,
misunderstood.
and to be fair, guys, the way that this works, since this is a relatively new event,
Right.
I can't even get the police report yet. Okay,
Yeah.
so I think we're going to be able to address that very, very succinctly, very quickly. But the information that we have right now, for example, my families, I call them my clients or families, none of these folks knew Ethan Crumley, had no negative interaction that they're aware of, no bones to pick either way. So as far as we know, at least as it pertains to our clients, there was no targeting of them per se, other than they were there. And he was obviously angry.
Thank you. Two quick questions, if I may. When we talk about responsibility and understanding in an overarching sense what the school's responsibility is in this, in your estimation, when you get down to an individual teacher who hypothetically notifies an administrator, but yet they are still named in this suit, does an individual teacher, in your estimation, have an obligation to go to a higher authority when they don't have that necessarily authority within the district system?
It's not my opinion. Michigan Compiled Law 722.623 requires them to do so, and specifically says that them notifying another person in their own agency, and actually mentions school, does not absolve them from responsibility. The Child Protection Act, folks, back in 1975, when it was enacted by our legislature, it was designed to encourage, in essence, almost force people to err on the side of reporting so that the experts could figure out whether there was a problem or not. What's happened is, since that time, and I will say politics, I know that shocks us all in this room, has taken over in the Michigan, especially on our judiciary at certain levels, especially back in the 2000s and 2010 timeframe when a lot of the law was made. It wasn't legislative. It stayed relatively the same. It's the judicial opinions that came out. So for example, the law says, I don't have to prove gross negligence. And it says, if a teacher fails to do this, they're responsible. That's what the law says. Then we get an opinion from the Michigan Court of Appeals in 2013 saying, well, even though the law doesn't say gross negligence and the proximate cause, Johnson, guess what? We say you have to prove gross negligence, the proximate cause, even though the law itself doesn't require that. So just where I come from, that ain't right. Okay. So plain and simple, to answer your question, the law is the law. If the law didn't, if the legislators did not want teachers to be responsible, think about this. Who spends more time with our kids, folks? And by the way, you're talking to a kid raised by two public school teachers, beautiful Saginaw, Michigan. Okay. So I get it. They have better insight often, or at least a different insight than we do, because they're there all day. If my kid was home and looking at ammunition, are you kidding me? They'd have to call the cops on me.
Forgive me. The point of my question, though, is if a teacher alerts a principal or a superior,
No,
they're supposed to do something
they're
further.
mandatory
Okay.
reporters.
Okay,
So if they have reasonable cause to suspect,
right.
why do you think they notified their person above them? Because they had reasonable cause to suspect. They can't get out of it. They're going to try to, and they're going to argue all sorts of stuff. But the question is it unfair to blame a teacher when counselors and so forth may have more experience in this? Well, first of all, we see the counselors blew it too, right? But the teachers, the answer to your question is simple. Under Michigan law, they have an obligation.
Thank you. Not
Yes,
to
sir.
monopolize, my last question
Sure.
I'd like to ask. In the Jeff Feiger news conference, he,
Who?
paraphrasing, he was saying he wants to make it hurt financially so that hopefully maybe districts become advocates in a greater context on legislative actions on perhaps gun reform, locking up weapons, background checks, etc. We've talked a lot about Second Amendment, and you mentioned hunting was a love of Tate's. How do you balance what you're seeking here in regard to possible reform legislation and getting this looked at? Is that part of the objective collectively of what you're seeking?
Second Amendment's in the Constitution. We're not talking about the Constitution, and you will see in 48 pages of lawyer gobbledygook, nothing about the Second Amendment. So we're not here to address that in particular. What we're talking about as it pertains to the Child Protection Act and the failure to report and investigate and really just get this kid help. It keeps everybody safe. And sadly, that overlaps with governmental immunity because of the Court of Appeals decision I told you about and the law that's now interpreted differently than it was in 1975 when it was passed. That now, if they're public school teachers, counselors, I have to prove gross negligence and the proximate cause up here, where if it's a private school, it would be simply negligence and what we call approximate cause. I know it's lawyer gobbledygook, but it's two different standards. And what the reality is, as Chris Desmond, our chief appellate attorney, could address, in governmental immunity cases, they more often than not get thrown out of court without ever going to a jury because of decisions like the one I just referenced, because the Court of Appeals and or Supreme Court back in the day were throwing them out and say, that's not high enough. You haven't proved it, even though we haven't even gone to trial yet. So it's blatantly wrong and it needs to be looked at. And that's why these two intersect, because of the way in which Michigan law has been interpreted, that I believe we are now interpreting it differently than the way it was intended. We intended in 1975 to help and protect kids. And now in 213 and on, it's to protect the folks that are guilty. Sorry. Jim.
The attorney for the school district said in the context of the other lawsuit that was filed,
Right.
and they've gone to federal court with a motion to put that on hold until the criminal cases play out.
It's called a motion for stay.
Right. Do you think that's justified? Do you think that's needed, especially now with your case? And yours is only the second one that's come forward, right?
Okay. As far as we know, folks, we are the first and only to file in Oakland County
Circuit court.
on behalf of anything, and it's state court
Right.
versus federal district court. So to answer your direct question, what I'm going to tell you is Tim Mullins, who I've had cases against as, sued schools in the past for years, they're going to file the same motion in my case. So I'm going to address my case because he's going to do it. And I will tell you, in 36 years of practice, I have won that issue about 99.99% of the time. There is no reason to stop us from moving forward in this case because the Crumleys are undergoing prosecution in the other case. I'm not going to be able to take any one of their depositions until their criminal case is done. That's fine. I got a case right now, Jim, 2 dead people and a truck driver who's in the middle of his criminal case. And in 2 years, I haven't taken his death. I don't need his death. I'll see him at trial. So yes, they're going to file the same motion. It absolutely should not stop at all. And Karen McDonald knows this about me. I've already reached out to Prosecutor McDonald and let her know that I represented these families. I let her know in advance that we were going to be filing this case. And although we have different interests and we do different jobs, I will not be stepping on her toes in any respect.
Having said that, since you've talked with Karen McDonald, do you think your clients will be called to testify in the criminal cases?
Yes. How's that for a succinct answer for a change? Yes. What happens in criminal cases here, now I'm going to lie and go through my criminal law, right? But no, in a criminal setting, what they always do is you have the families of the victims who obviously can't speak for themselves. So the question becomes, certainly somebody from the Muir family will likely be called. Let me use that word. For sure, somebody they probably want to call Keegan. And if the Gregorys and Keegan's medical professionals say that can't happen, and I would hope that they might let mom or dad, but these folks have already been contacted. They know that day is coming. So yeah, not something to look forward to, but yes, they will likely be involved.
Sir, Ethan Crumbley's attorney just filed an insanity plea during this press conference. What's your take on that, sir?
Well, here we go with criminal law again. I'm not here to talk about Ethan's competency to stand trial. What I know is this about criminal law. This is back UAD Law School in 1983, y'all. Here we go. When you have somebody that's premeditated and planned what he clearly planned for months and months and months, good luck selling a insanity plea. What you're really asking me without asking me is he incompetent? Does he understand the nature of his charge? Clearly he did, because I'm telling you right there, he was telling people I'm about to do this. Okay, so he understood, in my opinion, but they're going to fight about that. That's the criminal aspect. But do I think that the allegations in our lawsuit help him prove that he was insane? You've not heard me call him insane at all. This kid knew what he's doing. But the fact of the matter is, he clearly was disturbed. His parents clearly knew he was disturbed and did nothing. And then the last effort that we're aware of, until more evidence comes out, the school had absolutely 911 fire burning, and they did not do anything to extinguish the flames, and sadly ended up giving him the backpack that he used.
Other questions?
Without searching, I should have thrown it, of course. Sorry.
For the, excuse me, for the Gregories, is Keegan back in class? What's his situation these days?
Megan, you want to talk or no?
He's nowhere near going back to class, let alone functioning like a normal 15-year-old child. He wants to sit and watch movies that we watched when he was a young child. We have to check doors. We have to check under beds. It's completely, I don't want to say it's crazy that he is living this life.
Let me throw in, he's clearly showing classic signs of post-traumatic stress disorder. He is receiving help. So I will say publicly, okay?
Yes, he has a lot
And
of.
mom and dad, as you guys can tell, all like phenomenal. They're on it. We've discussed it. They're going to get, we hope, nothing but the best of care. But this is a long, long battle.
In addition to Keegan, you mentioned that you have 4 other children. Are you really going to send them to Oxford High School? I mean, can't you, you know?
Well, the next one in line, my daughter, she actually came to us and asked if we could look at private schools. So we have not gone down that road with any of them yet, just we're kind of day by day at this point. I think Oxford has a phenomenal program for kids, especially like her, that can take college courses in high school. And she's always looked forward to that. So I just told her, we'll decide when the time's right.
And let me also reiterate, I'm sorry, Jim. We're not here to call out every person that works at Oxford High School in the entire district and call them names and so forth and so on. We make allegations against the folks that the evidence is overwhelming that they violated the law. So that's what we're doing. But obviously these folks love this city and this place, or they wouldn't have their kids there.
Yeah, I want to make sure that our family's clear on that. We love Oxford. We've always had Oxford's back. And those who know us well know that, right? So we've always had teachers' backs. We've always had coaches' backs. We've always had the administration's back, right? One time they needed to have our back. They didn't, right? And it's a small group. So it's not a reflection of everybody in Oxford, right? Or everybody in the Oxford School District. Okay?
Sorry.
We love Oxford.
So are all of your kids still out?
No, we gave them the choice if they wanted to go back, and the younger 4 are back. None of them are in the high school.
And her other sons.
They're graduated.
To either of the families, what has interaction been like since this happened with school administrators?
I don't want them to talk about that, please. Sorry, guys. It's a thing called party admissions, and I'm not going to bore you with the law stuff, but I'll say globally, it's been lackluster. And the thing that we really don't appreciate is when you have a chance to have your attorney general doing an independent investigation, and then you elect, because your probably insurance company and your lawyer tells you to use a private company, signal 1, 2, 3, 4, right? Now, I'm going to tell you all this. U of M, Dr. Anderson, sex abuse cases, U of M hired an outside law firm to come in. It was scathing of what U of M did wrong, and they published the entire report for all of us to see. So what I want you all to do, please, please, is to hold Oxford accountable and tell them, share that with us, won't you? No way they won't. We'll fight them in court for it. That's why they did. And that's why we get what I believe to be whitewash letters from the superintendent of all the things that they didn't do wrong, that he probably had the assistance. And if he didn't, we'll find out. So I'll take his deposition and ask him. I'm sure he did.
Any other questions?
How about online?
Last call for Zoom participants to ask questions via the Q&A feature. Seeing none.
We'd like to thank everybody very much. Appreciate you guys. Thanks for.